I don't think there's a need to introduce Suzanne Stone, a friend of our faculty. And also, I think I always get invited to those conferences as a chair, as a friend of the legal historian community, because I keep telling my colleagues that do here legal history that these are always the conferences with the coolest people, and I'm not saying it as a joke. And I think, of the experts in Jewish law, it's not a coincidence that Suzanne is the Jewish law historian here.
I'm trying very hard to be cool, but that's not cool.
You're cool.
Hi. So first, very much thank you to Simon and to the organizers, because you forced me to learn something new. I really do not know aesthetic theories all that well, so but I will nonetheless, wade into it. So I took Simon's central question to be, should I be moving? Can you hear me?
Let's change.
Okay.
She can sit here.
Okay. I took Simon's central question to be, how do we investigate the aesthetics of conceptualism historically? And that diachronic move seemed to be incredibly welcome, because if we think about law as sort of one of the cross-cultural universals of law is to take social constructions and make them seem like common sense or natural, then Simon reminds us that what counts as natural or commonsensical will vary from culture to culture and from time to time. So one of I saw two very distinct ways in which Simon proceeded methodologically. One was through, the negation of other available aesthetic styles. Right, so those of you who looked at Koch's curlicue, right, the line of idolatry, this is not what Blackstone does. Or the surface depth model that was available in contemporary novels, this too, right, is not what Blackstone does, nor is it caricature, right? He was not Hogarth or Peter Goodrich. I have to say something about my colleague. The second is to attend very closely to metaphors Blackstone uses to describe his own project, and most especially the cartographic metaphors, that is map, blueprint, which befits somebody who's trained in architecture. So Blackstone is quintessentially an architect and not an archaeologist. So we have that wonderful list you gave us: rooms of convenience, habitable, simplify, harmony, shapes and how they relate to one another. This is an aesthetic, right, that one can immediately somehow vibrate with and place. It's less is more, right, and some kind of modern sense of space and lack of clutter. So what I want to do here, and then these concepts become, in a sense, and I'll get back to this in a moment, like furniture. That is, they are, in a sense, like material objects. So I want to say just a few, and unlike Blackstone, disjointed remarks. And then I want to bring in an analogy also from left field. My field is always left field, so that's where it will be from. So with regard to technique, so one of the techniques that the classic method and the modern method really rests on is that of editing out. Right? That's a very important technique, and I think that is and it's a crucial one, because it corresponds, I think, to our experience of conceptualism as maintaining itself by policing its borders. That is very much policing a canon and ejecting out all the outliers. And it could also be contrasted not only to Gothic clutter, but maybe also to a sensibility that from an aesthetic perspective I'm very given to, which is the discordant or jarring note, right? When introducing a discordant or jarring note in an otherwise harmonious space, which allows you both to appreciate the harmony but also then to make new connections. And I say this in part because a field that I do know something about, which is history of religions, this becomes a very important metaphor in a wonderful book of essays by Jonathan Z. Smith called Map is Not Territory, in which he describes, he's doing a kind of conceptions of space, but looking at cosmologies rather than legal space. And he describes, the sort of locative map where all things are interconnected and relational. And then he describes something called the in-between map. And the in-between map corresponds to this notion of allowing some incongruity and gap to still be there, which he insists is actually what would allow for more creativity. So that gets me to my second, somewhat unrelated point, which has to do with this tension about reform that Simon speaks about. And here I thought aesthetic theory did something very interesting, because I am used to thinking about conceptualism and this move towards internal coherence as actually being based on a conception of truth. That is, coherence is viewed, right, as the definition of truth. And since it's a definition of truth, since that is the test of truth in law, coherence, internal coherence, then why on earth would you change anything? Reform really becomes in some way, an utterly paradoxical move. But I took from what you wrote something a little bit different that was interesting to me, which was that Blackstone may have none of that baggage, that what he has instead is an aesthetic, right, an aesthetic sense, an attitude in which keeping something static over time is simply more beautiful. And it reminds me a little bit of the sort of Burkean appeal to the pleasing illusions of the provided by monarchy, that there's an aesthetic value here, and it need not be about truth. So now I want to do the comparison. What I want to bring in, especially because it really revolves around the architect blueprint notion, I want to bring in something that's probably more a comparison to Langdale than to Blackstone, but nonetheless I'll do it. And that's in the 19th century movement in Lithuania known as Brisk, right, which transformed legal study by offering a conceptual map of the rabbinic corpus. And the multitude of detailed rules, right, that is the common law mess of rabbinic law, was rethought as a system of legal constructs, right, and coherent principles. And these were understood to be pre-existing constructs, right, in which all of the later texts and traditions and dissenting opinions of varying kinds were approached as basically empirical evidence of the pre-existing constructs. And the words that were used by the practitioners themselves to describe these constructs were inherent, essential, fundamental, and interconnected. And it's very highly edited. It's a highly edited project. That is, if you look at the bookshelf of someone who is involved in the Brisker tradition, there are very few volumes on the shelf. Lots of stuff is ejected from the canon in order to accomplish it. What I want to note are two things. First of all, the underlying theology here, which is different from our mundane understandings of conceptualism. And that is, here we move to a situation in which physical reality conforms to legal reality. And one of the sort of ancient midrashic texts that's cited as a way into this conception is one that actually is participating in a debate that was rampant in the Second Temple as to whether the law is given at creation or it's given at Sinai. And this particular very well-known midrash describes the way in which God creates the world. And he looks into the Torah in order to create the world. And God is actually described as an architect, and the Torah is described as a blueprint. Right? It is the blueprint. So that is, the legal structures actually precede physical reality, right? And physical reality is grounded on them. And that becomes, in later thinkers, actually something that might be thought of as akin to an aesthetic theory. So if we think about the work of Soloveitchik, who's sort of famous philosopher of this approach, which was a family approach, he does talk about these legal structures as being a priori. And he is, since he was wrote a dissertation on Hermann Kant, I take him literally as referring to Kant, a priori categories. And what he really, in some ways, means is that it is through, right, it is these laws that allow us actually to cognize the world. So physical reality is experienced differently. And that, I think, is a very interesting aesthetic dimension to his thought. The second piece of this analogy that I wanted to focus on has to do with the Blackstone of the commentaries versus the Blackstone as a judge. Now, the Blackstone of the commentaries is exalted. Blackstone as a judge had something of a more mundane reputation. He was not viewed as a particularly great judge because he couldn't stand the mess. He couldn't stand real life. And this is the most interesting aspect, I think, of Brisk, which is that they elevated this form of legal conceptualism and study into essentially the definition of divine worship. And it was legal theoretical study divorced from any practical application. In fact, the curriculum rarely contained the responsa literature. You didn't study that. The responsa literature is sort of the case law. It was not even studied. So it intensified a theme that was already present within rabbinic notions, but it created this very clear split. So this way of conceptualizing was understood to be absolutely crucial, but it was not the law as applied. And that split, I think, it is such an important split, but it particularly, I think, is something to focus on today, because some of what's going on in modern utopian movements, is to kind of efface this split, which has been a very long historic split, and to bring this notion of theoretical law, which is law in God's eye, down to the practical level, which is actually not a level at which it has always or almost always functioned. So.
Thank you.